All right, in this lecture we're going to look at Incoterms 2010, those terms that are standardized in the current version of Incoterms. And the Incoterms 2010 rules are the standard set of trading terms and conditions designed to assist traders when the goods are sold and transported. Now, each Incoterm rule supplies the obligations of each party, who's responsible for services such as transport, import, export, clearance, etc. It's going to describe the point in the jury in which risk of loss transfers from the seller to the buyer, and does so by agreeing on the Incoterms. These important elements can be set out and incorporated into the sales contract without the buyer and seller having to go back and recreate these contractual provisions. And because there's been so much study of Incoterms, each party should know exactly where responsibility lies in the event of loss or damage or any other sort of mishap, anything else that happens to the goods in transit. Now, Incoterms are really 11 rules. They're 11 abbreviations, and these abbreviations, which are three-letter abbreviations, are very powerful. They're divided into two main groups, and we'll go ahead and discuss all 11, but I'm only expecting you to know 5 or 6, and we'll talk about those as they come up. The second rule is for sea use only, where there is transport only by the sea. The group that the rule falls into is not as important, certainly not important for your test. Instead, I want you to know, what does the rule mean in terms of risk of loss. The first is EXW. And EXW is an abbreviation for Ex Works. And Ex Works means the risk of loss passes when the goods are made available to the buyer. So when I take the goods out of my factory, that's the works part, and I place them on the loading dock of my warehouse, I have delivered the goods if our agreement is EXW. EXW says I deliver the goods as soon as I place them on the loading dock. So maybe you send your own transportation, or maybe you ask me to arrange for transportation. Doesn't matter. Risk of loss passes when I made those available. This is obviously the best possible term for the seller and the worst possible term for the buyer. Nevertheless, if a party's willing to share more risk of loss, it may be able to negotiate a lower price. A seller who is eager to sell the goods and is concerned about risk of loss may be willing to accept a little less if the risk of loss is taken on by the buyer. So that's an important element of contract negotiation, has to do with risk of loss. So EXW, know that one just because it's the most dramatic form. FCA, free carrier, this means the goods, risk of loss pass when they're placed into the hands of the carrier. Carriage paid to, CPT, you don't need to know this one as well. Essentially, it means that the cost have been paid up to a specific specified place. Carriage and insurance, CIP, carriage and insurance paid. Generally what happens is the seller will agree to pay for the carriage of the goods, the shipment of the goods, and the carrier may agree to pay for insurance. However, risk of loss is borne by the buyer. I'm going to upload some documents and they'll show you exactly where these different terms pass risk of loss. But but you should know CIP. Delivery at terminal DAT means the goods are going to be delivered when they are placed, not at the seller's place of business, but at the closest terminal, or the terminal that's specified in the contract. So DAT, you should know that one. And you should know DAP, delivered at place. This refers to the place of business of the buyer. So risk of loss will pass if we have a contract DAP when they are placed at the hands of the buyer, or at least tendered for delivery. DAP is the Incoterm that is most favorable to buyers and least favorable to sellers. If you have a contract calling for DAP, that as a seller, you're going to cover the risk of loss at any time before those goods are placed into the hands of the buyer. But you may be willing to take on that risk. If you can afford insurance on the goods during transit, if you've got the cost of transportation taken care of, the buyer may be willing to pay more to avoid having that risk of loss for DAP. Delivered duty paid, again, what this means is any export or import duties will be paid by the seller. This is not one that you need to know for your test. Now there's a couple of these you need to know because there's some key distinguishing characteristics. And the first is FAS, or free alongside ship. And what this means is that the risk of loss will pass when the goods are placed alongside the ship on which they are to be loaded. So if we have a contract that calls for FAS, that means if I as a seller place the goods into the hands of my delivery service or to any delivery service, I still bear the risk of loss. And I will bear the risk of loss until those goods reach the side of the ship that is going to carry them away. So FAS, free alongside ship, means that the risk of loss is going to pass when the goods are placed next to the ship on which they're going to be transported. FOB, free on board, means that the risk of loss passes when the goods are actually on board the ship. The key distinguishing characteristic is the possibility of damage while being loaded. The container falls into the ocean. The container opens and spills out half of its contents. If it's FOB, if that occurs during the loading of the goods, the seller bears the risk of loss. Buyer doesn't have to pay anything. FAS, the buyer would have to pay for the goods, even though they arrive damaged or not even at all. Cost and freight CFR, again, this is commonly used in which the seller will agree to pay the cost of the shipment and the carriage of the shipment, and the seller will essentially retain the risk of loss, but will insure against them. And the same with CIF, cost, insurance, and freight. You don't need to know either of those two, just know FAS and FOB. So how does it work in real life? Well, here's the format, the typical format. And again, I'll have a separate lecture on some sample documents. It'll be something like CIP, Hong Kong Terminal 4, Incoterms 2010. So there's really three elements there. There is the three-letter abbreviation that we've already gone over. So a three-letter abbreviation. There's a precisely defined place, Hong Kong Terminal 4, and there is the applicable edition of the Incoterms rules, here Incoterms 2010. So every Incoterm will resemble that phrase, and then those three elements must be present. If those three elements are there, then it's not an effective use of Incoterms. And the court or arbitrator would have to look at any number of factors extrinsic to the agreement. Therefore, you, as future business people, always use the Incoterms in the proper format. That prevents a court later to come in and try and figure out what it was that you did or you wanted to say. So in conclusion, allocation of risk is a huge part of the contracting process. It can govern our cost, our price, delivery terms. Allocation of risk is an essential part of the contracting process. The CISG includes rules for the passage of risk, and the standard contract terms, Incoterms, help to govern risk of loss as well. As always, if you have any questions, be sure and let me know. Send me an email. Give me a call. I'd be happy to go over all of this in more detail. Thanks.